So real quick, if you could just tell me your names and spell them for me.
Sure, I'm Costigan. I'm the Chief Judge of the 11th Circuit.
William Yodar, presiding criminal judge.
So the first question I have is that one of the things the Safety Act did was allow for police to cite and release for low-level offenses. From the judicial perspective, how has that been going for the last couple of years, as far as people actually appearing and stuff like that?
We have not had any issue with the failures to appear. I mean, at this point in time, when somebody fails to appear, there's a warrant that's issued for them, and the bond will depend upon the nature of the offense, how many times they fail to appear, that type of thing. But our preference certainly is to get them to court in the first place. A lot of folks at this point in time are given citations to just appear in court, and for the most part they show up. For lower level offenses, driving offenses, those types of things, they'll be given a notice to appear by law enforcement at that point in time. For the most part, they show up. And if they don't, then we can get them here.
Okay.
And so I don't anticipate a huge change with regard to that. But we'll have to see how it goes, once the act comes in place.
So the new rules on the distinction between like a mere failure to appear and willful flight haven't been put in place yet. You understand my question?
The act isn't effective for another 60 days, so.
Okay, so they haven't come into effect.
Never been in the portion of the bond aspect of the act has never come into play. Because that portion of the act was found unconstitutional by the judge in Kankakee, and then the Supreme Court, that went up to the Supreme Court stayed that on December 28th, and so that portion of the act has never come in place, so we don't know how that's going to operate. And with my last answer, again, with the current system we have in place with the cash bail, that's how it's worked. And as to whether that's going to change with the Safety Act, it's kind of a wait and see type thing.
Okay, and my last question is what do you think is going to be the greatest challenge in the next 60 days in getting this fully implemented? I know that you said you were ready at the beginning of the year and that you just have to dust off some things, but what are some of the biggest challenges that you perceive are going to facing and getting it fully implemented?
Well, some of the biggest challenges are the things we don't know at this point in time, because the Act does make significant changes to the justice system, and as to how those changes play out, the interpretations of the Act, with most laws we have appellate interpretations to say, here's how you're supposed to interpret it. With this Act, we have no interpretation, and so it's going to be a lot of judges having to say, well, this is what this means and this is what that means, and we'll have to get some appellate decisions, some Supreme Court decisions in terms of this is what it means, so we know further. And in the meantime, you might have some inconsistencies based upon how people feel the act should operate.
Okay, well, thank you very much. That's all I have.
Okay.
Thank you.
Have a great day.
You too.
Thank you so much for turning into Agitation Rising, your source for local, leftist, independent journalism in Central Illinois and beyond. You can always find our articles on our blog, link in the description. Please like, subscribe, and comment. Agitation Rising is under the Strange Corners of Thought umbrella, so feel free to contribute directly to our Patreon, or donate via PayPal or Cash App. Again, links in the description. Keep agitating, keep rising, and we'll see you on the other side. Thanks.